authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters that is where a question of principle arises, and of all the three organs of government, only one organ stands out for standing on principle, the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to administer that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
My Lord, I'm a full-time lawyer, full-time. I appear in the United States Court, High Court, Court of Appeal, and I appear before what you are arguing here is a matter of law. It has absolutely nothing to do against any of you, either individually or collectively. So we are arguing this matter as a matter of principle, saying that things have not been done properly. And it's because, my Lord, and my lady, Kenya is an interesting country. There is a book here which I read from time to time. The Constitution of Kenya Commentary. The Constitution of Kenya Commentary. There is a section in this book which is very interesting. And so I came in to this matter. I would have been able to go through and flag a particular sentence. There's a sentence which says this. Kenya is one of the most corrupt countries in the world. In this book, it's written there. Kenya is one of the most corrupt countries in the world. And my Lord and my lady, suspicions are cast on the national security. Suspicions are cast on the Senate. And my Lord, we appear before the Lord. When suspicions are cast on this court, we stand up and protest loudly. All that you are arguing respectfully. My Lord and my Lord, let this matter, when the court was to land friend said, let this matter go back. If he endorses you, I commend you. We have no problem. You have done her work properly. But let things be done in a proper manner so that we do not send out the wrong signals, so that we do not send out the wrong perception that there is corruption going on in National Assembly, in the Senate, and in the judiciary. Let the matter go back. Now, it was said, that certain individuals were above the law. That's not correct. When you are appearing before the lordships and my lady, we should show that actually we are really learning the law. All of us, as the land friend, is to keep upon that word properly. All of us are under the law. The judges are taken to court. The chief justice can be taken to court. The speaker can be taken to court. The president can be taken to court. And in fact, the case of Trump versus Vance, a United States court, 9 Supreme Court judges made it very clear that the director of criminal investigations is at liberty to investigate on the President of the United States. It's my humble submission that we shall be advancing the same argument. Like in this case of Kachagwa, no director of criminal investigation was called or summoned to give evidence. Am I wrong, Mr. Minister? I'm right. Thank you. I'm glad I'm still right. No director of criminal investigation was summoned to give evidence. This is a lacuna. This destroys the whole case. My Lord, there is something else I would like to say to you, very, very respectful. Conflicts at work. We are always quarreling with people we work with. It's normal. I happen to know that Chief Justice Miller and Sergeant Woods never got on very well at work. They quarreled from time to time, but they couldn't work together. I happen to know Chief Justice Trevedian and Justice Martin, while not friends, they used to throw some things against one another, but they continue to work. Some of us who have been married and so on, we know that actually at times a wife can quarrel, and at times a man can quarrel, but they still continue to live together under the same roof to make sure that the children actually have a parent, father and mother. And that's what we're saying. This nation has to survive the crisis. We cannot destroy the nation by saying because the president and deputy president quarrel. That is very, very naive way of looking at life. Thank you very much. And I shall get advancing the arguments of alternative dispute resolution. I put them on notice. We shall get advancing the notice that alternative dispute resolution. You can still get President Reconciliation, we can get our archbishops, we can get our retired Supreme Court judges to talk them out and continue to work. But we cannot abandon the Deputy Chief Justice because the two are going to really get on well. That is a very, with respect, that's a very childish way of approaching this. Thank you. I have a book here that can donate to you. To end the presidency.
I have it also.
Oh, thank you. Yes. May I say I'm very happy that you read so widely.
I always do that.
Maybe I can be allowed to respond to one issue.
So Senior Counsel Paul, are you responding?
No, in the interest of time, I will go along with the submission.
Then you can give me one minute.
Just 1 minute.
Your name again?
Yes, Kimoto Teresio and Jiro Makazi, the first Kimoto and Company Advocates, Kerugoya. Yes, I wish to respond just briefly on one issue. That is the issue of service. There was an issue raised that the notice was not necessary. And we insist that because today was inter-parties hearing, then the notice was necessary. We also wish to say that one can do a good thing, but at the wrong time. And the reason why we are saying this is that the Chief Justice, though we are being told, you have been given a memo and directed to the portal, which I have checked right now, and it's not there. The last thing that was there was a ruling delivered by Honorable Chief Richard Mwongo at Kerugoya, and there's nothing else. So the Kerugoya matters, they have nothing else there. And we have been told this internal memo was filed as petition E14 of 2024. So that is not true. However, we wish to say that once a court sits on Saturday, and then at a wee hours, it could look like a good thing, but then a wrong thing. Because the perception people will have is that there's something fishy going on. That is what we are crying out loud and saying it is not necessary. And the last thing that I wish to note is that justice cannot be served expeditiously while infringing the rights of others. So we are very much in order. Fair hearing is a must. And we cannot be told it's for the interest of quick delivery of justice that we infringe other people's rights. So we are saying, let us be heard fairly, and we be given enough time to respond to all the motions that are before court, and also the petitions or the responses filed, so that we cannot be prejudiced. That's all.
Your Lordship, with your very kind permission, my name is Kindiki. I just have one issue to respond, and that is by Professor Rigathi on. Your Lordship, Professor was so precise as to the time when the file was transferred from Kindiki. That is at 3:45 p.m. Your Lordship, I have also taken the liberty to look at the order that was issued on that matter, and it was the order was issued at 3:37 p.m. So in 8 minutes, Your Lordship, the petition E015 was transferred, or rather was transferred to the Chief Justice. Your Lordship, in our matter, that is petition E014, it was transferred to her ladyship on 11th of October. So those are 8 days. Your Lordship, therefore, we don't understand why the expediency that came in the sense that one petition is transferred to the CJ in 8 minutes, while our petition takes up to 8 days for it to be transferred.
I think the petition was filed in Karagoya. The lawyers who did that yourselves.
Yes, Your Lordship.
You should answer that question.
Your Lordship, and that's
Yes, that is your question to answer. You cannot pose it to us.
Your Lordship, it's in the context of the matter in which.
Yeah, you must balance all issues. You don't, when an issue favors you, you don't raise it up. When it doesn't favor you, you want to put it down.
I'm well guided.
The issue orders which came from Karagoya were your orders. Thank you very much.
Thank you.
Thank you very much. Before we get final orders, please keep quiet. Before we get final orders, we as a bench, we want to thank all counsel for the mature way in which we have conducted these proceedings, and the legal evidence which we have put. They are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Leadership, perhaps before you turn off, there could be a possibility, Your Lordship, that it is imperative that we have the other files that were not before you coming up for a mention tomorrow, because there is an application for your recusal that I have filed. I would perhaps also wish to seek directions on it.
May it please the court. Once more, my name is Dr. Eboso, and